So good afternoon and welcome to another edition of Digital Transformation Thursdays. Welcome everyone. I'm JJ Dicini. I'm the managing partner of Dicini Law Office. Um, and as you know, we're holding this series of free webinars to celebrate our 20th year. And today, we're very happy to have this session, the second of our series on human rights, which is a very important topic. But today we're focusing on two particular rights which are different but are also highly interrelated: freedom of expression and privacy as a human right, which I think these are two very important rights that have been impacted by digital change, meaning people coming online. Initially, when you think of freedom of expression, you think the internet was a great equalizer, where the power or the ability to reach millions of people is no longer within the domain or the purview of mass media companies which are privately owned. And in a sense, I think that's true. But in another sense, what we've seen is that we've shifted from that kind of space into another space now, where which we call social media. And what that involves now, I think, involves a publicly accessible but private sphere. So Facebook and Twitter are privately owned. They are profit maximizing companies. That's what they exist for that purpose, for the purpose of making money for their shareholders and giving them a good return. But on the other hand, that's also the platform in which a lot of interaction happens. So it should be interesting to see how that plays out. And then next, we will have a discussion on data privacy as a human right, which I think has not been sufficiently discussed. And with the Data Privacy Act now in force in the country, it's important to have that conversation. I'd also like to welcome everyone, and I'd also like to inform everyone that this is for free, the webinar is for free, but if you want a certificate of attendance, kindly go to our website, www.dtt.ph, and then sign up on the Zoom interface for this event, and then you will receive an email and an instruction on how to get your e-certificate of attendance. It's automated. We would like you to make a small donation, and you'll see on the interface, and the money goes to our what we call DTT Donates, where we give it to COVID frontliners. And I would also like to thank our speakers who also contribute to that, because they give their time here for us, for everyone. Very valuable, their inputs, and we'd like to thank them because they are also helping us in making these donations and helping our COVID frontliners. Please let us know where you're coming from, and then I'll sign up, and I'll do a shout out later. Okay, so we'll go on to our first speaker, who will speak on freedom of expression, and that's Romel Bagares. He is a graduate of the UP College of Law, having earned his LLB in 2003. His undergraduate was also at UP with a degree in communications research. He also completed a master's cum laude in social and political philosophy at the Free University of Amsterdam. While he was in law school, Romel was a journalist. So he knows a lot about freedom of expression and freedom of the press for the Philippine Star from 1995 to 2003. And then after going out of law school, he started doing work for the Center for International Law, Philippines, for which he is the executive director. And through that organization, actually, Professor Bagares has been involved in a lot of groundbreaking cases. I hope he will discuss some of that, where he has actually been fighting for human rights in the courts as a lawyer representing a lot of clients in very important cases. I hope he goes into that. He's also a lecturer at the UP College of Mass Communications, lecturing on the topic of law of mass media. He also teaches at Lyceum at San Sebastian. And he was also a participant in a lot of international fora, including the University of Sydney Faculty of Law and Media Center's Digital Rights and Governance in Asia Research Workshop in 2018. And he's also a member, he's a resource person, regional consultation resource person for Facebook's Oversight Governing Board since 2009. He is engaged in private legal practice. He consults in various areas such as data privacy, microfinance, and renewable energy. So I'd like to call on Romel Bagares. Romel, there you go. Welcome.
Thank you, Jay, for the generous introduction. Good afternoon, everyone. It's a pleasure for me, as well as a privilege to be part of this undertaking of the Scenic Transformation Thursdays. Now, given the limited time, let me drive directly to my talk, which is titled Not As We Imagine It, Free Expression in the Digital Age. And my talk looks at the theoretical and conceptual frames for understanding the current digital landscape in relation to free expression. So I have 3 main points and a conclusion. So let me now open my, share my screen rather for my PowerPoint presentation. Sorry, a bit more. This is not showing in my, oh here, all right, found it. Okay. So not as we imagine it, free expression in the digital age. Now, when you talk about digital landscapes, I think that we need to rethink our established doctrines on free expression. And usually, as we discussed, the landscape that has changed, the situation that has changed after the rise of social media. And going to my first point, we of course have this established constitutional doctrine, which is from the classical liberal idea of giving constitutional and legal protections for free expression, but chiefly focused on individual rights. And these are framed as guarantees against encroachments by the state. And we understand that to be something that's right, found right in the heart of the Bill of Rights. So we have this constitutional understanding that free expression really is all about individual rights being protected from state excesses. And some of you might be familiar with this case, People versus Marty. It's actually not a free expression case, but it expresses what the Bill of Rights says when it comes to free expression. It says that the Bill of Rights is cast as an ironclad protection for personal autonomy against unwanted state encroachment. And this case borrows from the words of Constitutional Commissioner Joaquin Bernas when he explained before the commission that drafted the Bill of Rights, the Constitution, 1987 Constitution, why we have the Bill of Rights. And let me quote from his discussion here. And he says, in part, protection against whom? Protection against the state. The Bill of Rights governs the relationship between the individual and the state. Moreover, when you talk about free expression, it also rests upon this entire idea that the achievement of maximal protection for personal autonomy is anchored on a democratic deliberative process. So in this process, there is an assumption that the discussion is rational, and that rational discussion enables all citizens to arrive at the truth that they need for making important democratic decisions. And that design is something that's found in our own constitution. And the root of that design is actually in the case of Whitney versus California. And there's a very and very uh, eloquent passage there talking about the design of the US Constitution. And let me quote, "The framers of the Constitution knew that order cannot be secured merely through fear of punishment or its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed remedies, and that the fitting remedy for evil counsels is good ones." So you can see here that at the heart of the Constitution really is this idea of rational agents, of individuals who are informed in the discussion, and on the basis of that rational discussion and information that they get from the discussion, they are able to function as responsible citizens when they engage government, when they make decisions pertinent to government decisions. And so if we talk therefore about the history, the history for the last 100 years, that is, if you talk about the 20th century, we have this model of regulation of free expression, where the state directly engages speakers. So through different methodologies of regulation, the state regulates the exercise of free expression of different speakers. So you have individuals, you have corporations, well, what we now call legacy media. You have institutions, labor unions, and the like, who exercise this freedom of expression. And according to the vision of the Bill of Rights, there's this wall that protects them in case the state overreaches, in case the state actually extends beyond what the law allows by way of regulation. And this is the model that courts have used in the US, in the Philippines to a great extent, developing a host of jurisprudence on time, manner, and place speech regulation. So let me now go to my second point. Okay. But all of that, we of course changed with the rise of big technology, the social media. When we talk about social media, we discuss here the ubiquity of big tech corporations like Facebook, Twitter, YouTube, along with other infrastructures of new media. And let me point to three potentially shaping or distorting characteristics of these new media. And I think that you have some idea of this, at least by intuition. By intuition, rather. The first is that we have this challenge of big technology, the challenge of big tech, YouTube, Facebook, the social media apparatuses to actually enable the speech of billions of people. This is a latest figures from Hootsuite. We are social, which is an organization that tracks the use of social media around the world. And you can see that right now there are 3.96 billion users of social media. And that's more than half, 51% of the world's total population. So consider, if you consider these figures, therefore, you can see the ubiquity of social media. And that is really happening at a fast rate, and it's increasing. The numbers are increasing as we speak. And this is actually enabled because we have this entire ecosystem of new media infrastructure. So that includes internet, satellite communication, ISPs, and all these other institutions that make social media possible. The second point is that big tech has such an extensive reach that even rivals, if not exceeds, that of states and international organizations. So if you consider that Facebook, for instance, you practically can find Facebook everywhere. Almost everyone in the Philippines has a Facebook account. The same goes for Twitter, maybe to a limited extent in the Philippines, but Twitter also has a huge territorial reach. You have YouTube. A lot of people are also on YouTube and other social media networks. In China, they have their own social media systems, and they also straddle the lives of hundreds of billions of Chinese citizens. So you can see that you can in fact say that social media companies have such tremendous economic, ideological, and informational power that poses challenges, unique challenges to states, not just the US, but the Philippines, practically every other state on the face of the earth, given this tremendous power that are enshrined or that rest in the hands of these social media companies, and most of them are, in fact, based in the US. And a third point that you must consider is the technological infrastructure that's required to make the big tech's operation possible on a day-to-day basis. What you see here is the increasing penetration of online and digital consumption as a result of COVID-19. So it's there's a leap in the consumption of people of different modes of social media. Now you have streaming services. Of course, people spend more time now on Facebook or YouTube or Twitter, or even sending messages through Messenger, or they explore other mobile apps. And that's because of the free time that has been made possible by the pandemic. Of course, a lot of people are now working at home. They don't go that much now to their offices, given the lockdowns that have happened in the last few months, and uh, and all these activities, of course, of new media is founded on what scholars call surveillance capitalism. The and and this is the idea that uh, these companies need continuously to collect personal data for commodification. And the social media networks that we know, they have such an expansive and extensive infrastructure for collecting personal data that you will not find in any ordinary state. Maybe maybe they would be comparable to the intelligence activities or capabilities of the United States or maybe Russia. But on the whole, this kind of capacity you will not find in an ordinary state like the Philippines. And if you've seen this documentary Social Media, you know that the surveillance capitalism system is very addictive. Uh, the moment you wake up, open your Facebook, you look at what your friends post, and even before you sleep, you also check on your Facebook. So it's an addictive process where we cheerfully surrender personal data to Facebook, to Twitter, so that they can use it freely to earn money by way of advertising. So you really have these technical capabilities that dwarf those of states. And when you come to think of it, it's really scary. And now people talk about the Internet of Things, the integration of practically everything, so that you have all these integrated means of collecting personal data. And some philosophers are starting to talk about the idea of transhumanism, in which human beings will become increasingly identified with the data collected about them. And in fact, the next step towards that is the integration, of course, of flesh and information. So these three things that we see arising from the ubiquity or from the prevalence of social media in the life of a lot of people around the world, almost 4 billion now. Of course, these have intended and unintended consequences. And what are these? Well, there are 5 that I've listed. I'm sure there are more, but for purposes of our discussion, we'll just talk about 5. The first one is free speech by algorithm. So we thought before that it would enable free speech, but this data surveillance system is rigged, such that certain people are lumped according to interests, and the feed that you see on your social media account on Facebook is based on data that had been collected by Facebook about you, the sites that you click, the people you interact with. And there's this famous quote from the German philosopher Jürgen Habermas, where he said that a post-truth democracy would no longer be a democracy. He was actually writing from the year 2006. So at the start, in the early 2000s, maybe late 1990s, the promise of new media was democratization and increased enlightenment for global citizens. But what happened is that what we have now, as Burmas noted, are bubbles where people are, stick to what they think is appropriate for them, where people think alike, and there's hardly any interaction between these different bubbles. So this was actually the very first time the word post-truth was used in 2006, and Habermas was actually remarking on the remarkable phenomenon of the election of George W. Bush to the U.S. presidency in 2006, where he noted that for people, facticity or factuality really does not matter. What matters is that what they hear, what they imbibe from social media are things that reflect their own value system. And 14 years later, we have Donald Trump, we have QAnon, which is a very widespread conspiracy group now in different parts of the West, and emanated from the US. And we have what we now call the troll farms. Uh, um, a few years ago, someone made a Twitter account of Habermas. Is now more than 8 years old. It's actually someone else, and not the philosopher, but the guy who tweeted, who used Twitter, posted several statements lifting from another essay that he wrote, and in that essay he lamented the fragmentation of social and political life as a result of social media. The second unintended consequence is what I call death by speech, and we have seen its gruesome consequences in Myanmar, the genocide against the Rohingya people. And the allegation is that Facebook abetted a genocidal campaign that was launched by the Myanmar government against the Rohingyas. And Facebook was passive. It did not lift a finger to stop all these incitements posted on Facebook, as a result of which tens and thousands of people have allegedly been killed. And today, it's a matter of debate whether or not Facebook may be held liable in some way for what is considered by some as grave omission on its part, as a result of the use by certain interests in Myanmar of Facebook facilities to promote incitements to genocide. A third unintended consequences of the rise of social media, of course, is political manipulation. In the slide, you see the story about what Cambridge Analytica did in the Philippines that became some sort of a blueprint for the use of social media in the US, also to influence elections. And we know now a lot about this because there was actually a whistleblower, somebody who was deeply embedded in Cambridge Analytica, and he exposed what was happening. And the model that Cambridge Analytica allegedly used in the Philippines became part of the playbook for Donald Trump's own presidential campaign. The fourth consequence is it's something that we constantly talk about, political polarization. So when you think about what's happening to us in the US, you're looking at the current count in the presidential elections. You see this huge divide between among Americans, and to some degree, a lot of experts, a lot of commentators attribute that really to the rise of social media and the bubbles that came along with it. Fifth is political interference. Now, recently, Facebook announced that it removed accounts targeting the Philippines from China. Um, uh, uh, and they basically said that we have to remove these accounts because they exhibit coordinated inauthentic behavior of a foreign or governmental entity, and it's a real uh, possibility, a reality today, that you will have these big governments interested in how the political life of another country would unfurl, and they can actually use social media to spread certain misinformation campaigns to influence political decisions being made in that other country. Um, and just recently, a group of scholars released the Oxford Statement on International Law that deals with protections against foreign electoral interference through digital means. So there's this recognition that states have an obligation, especially if they're the ones targeted, to stop these foreign political interference. And before, in World War II, it was an expensive and very complex undertaking, for British agents, for instance, to influence um, American leaders to help Britain in its fight against the Nazis. They have to put up an office in the U.S. to deal with politicians. Today, you don't even have to step on foreign shores. You just have to have a troll farm that you will use to spread disinformation or misinformation, for that matter, to influence political decisions being made in the target state. So now we have discussed about this rise of big technology in social media and their consequences, how they have changed the landscape, and what do we do then? Do we have recourse? What are the new doctrines of free expression that we can use? Let me discuss this a proposal by Professor Jack Balkin from Yale Law School, showing that free speech can no longer be explained in terms of the dyadic model that we discussed earlier. So we now have this triangular model of free expression. On one side, you have nation states. The dyad earlier, with dealing with end users, citizens, civil society, and legacy media and the like. And on the other side, you have these new media infrastructures that make social media possible. Platforms, the ISPs, domain name systems, of course, payment systems. When you have your paid account, you have to pay through credit cards, and all these credit card and payment companies, PayPal, they enabled, in fact, this entire ecosystem, because without them, you cannot derive any profit from end users. So there's this interaction, the co-optation. Sometimes the state would co-opt, or sometimes the corporations would say that it's to their interest to cooperate with the state. So there's always that the dialectical relationship in this triangular relationships between these three factors in this triangular model for expression, and we will look in detail at how at their dynamics. So before, you have this regulation directly. If you have a newspaper publishing stuff, this will go directly to the legacy media. But today, dealing with social media, of course, legacy media is still there. We still have newspapers, but then you have Facebook, you have YouTube. So you have these states and international bodies going after the intermediary who enable your Instagrammer, your blogger, or your Facebook poster, or your Twitter. So there's this additional aspect that's not accounted for by traditional media. So, for instance, you now have this entire infrastructure in social media companies doing private administrative prior restraint. So we know that in the Philippines, we play a large part in censoring all these gruesome, inhuman photos uploaded every day on Facebook. when I was attending the discussions with the Facebook regional office on their external board, uh, we were told that on any given day, up to 200 million pictures are uploaded on Facebook around the world. Can you imagine that? No? So you need an army of people, aside from the algorithm, to sift through the chaos of the 200 billion photos and to see if any photo violates the community standards of Facebook. So now they have this oversight board that I think it started operating a few months ago, but it's been criticized for doing too little, too late. No? So there's also this a group that says that calls themselves actually the real Facebook oversight board, no? Criticizing Facebook because it didn't really deliver as promised. Now, there was a lot of discussion when they were talking about establishing the oversight board, but the oversight board finally came to be. A lot of people were disappointed by the powers that Facebook actually gave to the oversight board. But the point is that you really have this something analogous to your administrative prior restraint procedure in government, no? Except that this is private governance. It's a private company setting up its own system. So, for example, Google, when faced with a suit enforcing the right to be forgotten, the European Court of Justice said, well, you need to put up now this system. So when somebody complains, you decide if the person complaining does not agree with what you did with this request, he can go to court. So there's now some sort of a private administrative exhaustion, no? Requirement before you can go to court, and that's now set in Google. So this is an example of private governance occasioned by the rise of social media, given the amount of information of personal data being amassed by these social media networks. And you therefore ask, what will be the parameters? Facebook has its uh, standards, community standards, but how are we sure that they're doing what they should? What about free expression? What about the public interest that goes into all these posts? One course of standards is what has been called the Manila Principles on Intermediary Liability, and this was actually drafted in 2015 on the occasion of the RightsCon. It is an annual gathering of people interested in rights, free expression, information, and they drafted these principles. What's common about these principles is that they actually look at what Professor Balkin calls curatorial due process and fiduciary and information fiduciaries. So there's now this notion of curatorial due process, because what's being removed or blocked is free expression, and there's an expectation that the curators, so those people exercising private administrative prior restraint of some kind, they embody in some way the public interest that goes with all these posts being made on their social media sites. So given this, therefore, we need to expand our understanding of rights. No? So if we just limit ourselves to free expression, to the Bill of Rights understanding of free expression, then we're limited to the encroachment of state. And we saw in this model that already social media networks are in some way practicing some sort of censorship, what's called collateral censorship, or private administrative prior restraint. And the question, therefore, for us in our own system, do we have something that we can also use to understand better this dynamic? So in our own constitution, outside of the Bill of Rights, we actually have these several procedures in the constitution. I'm just going to flash them quickly. These are provisions of the constitution dealing with the right to information, balanced information, and it also, in fact, mentions free speech and free expression. There's also the policy on the development of communication procedures and institutions that respect free speech, and that goes into what we want as a people, our aspirational goals as a people. There's the provision that prohibits monopolies, and we now have a competition commission, which is one of the operationalizations of this provision. And all this really deal with the problem of sociality. If you only look at the Bill of Rights, it's just individual rights, and we have to think about institutional and communal rights that are, in fact, independent also of individual rights. We also have to say and to consider that structural and institutional rights are of value in themselves. So if you talk about free expression, therefore, we can actually have a better appreciation of its flourishing within a constitutional framework where we can find not only structural pluralism, but also viewpoint pluralism. What about our jurisprudence? So earlier, we saw that jurisprudence is quite limited to individual rights, but we have this case of Bacolod versus Comelec, which actually expands that to a great extent. So on the one hand, you have, according to the ponente here, Justice Leonen, it's connected to the right of the people to participate in public affairs, including criticisms of government actions. It also goes into the marketplace of ideas. So you see there the American case that we talked about earlier, the constitutional design of rational discussion, and then the individual autonomy, self-expression that enhances human dignity. And then there's this discussion of markers for group identity. So it's not just, free expression is not just for individual rights, but even for communal, for group rights. And finally, also protects individuals and minorities against majoritarian abuses. Because if you only consider democracy as a majority of 50+1, then you have the potential for a totalitarian system. So free expression, according to Bacolod, to the Bacolod case, is also a protection against majoritarian abuses. Then there's also this case, landmark case, in the name of Professor J.J. Dicini, with respect to cybercrime regulation. This is in terms of expanded actual malice test for cyber libel. So even if, according to this case, it's actually not often considered that in this case, there's actually a ruling by the court that even if a journalist is grossly or extremely negligent, it cannot automatically be inferred that that journalist is guilty of actual malice. So that can be used as a defense in criminal libel. Of course, in this case, it was also held by the court that there's no intermediary liability for cyber libel if you're just retweeting or sharing or reacting to a post that was later on adjudged to be libelous. And then you have the section in the court's decision that invalidated the takedown clause and the real-time data collection clauses as unconstitutional without court warrants. No? And these are really important. These are landmark holdings of the court in this case, and that deals with digital rights, with our digital life. And in closing, I would like to end with this quote from the philosopher Urjan Habermas, that talks about the continuing challenge that we have in social media. And I'll just quote the last line, but the rise of millions of, he's talking here about all these possible positions that can be taken. As many as you have social media users, they have led to the fragmentation of audiences into all these isolated bubbles. And that's really the continuing challenge for us. How we should be able to bridge the gap, given the promise of social media and the reality that we have. And we see that being played out in stark reality as we look at the news of the presidential vote count in the United States. Thank you and good afternoon.
Thank you, Romel. Thanks for that presentation. Let me see. We need to. Can you stop the sharing for a second? There you go. Hold on. Okay. So, thanks for that. Oh, hold on. Sorry, let me just stop this sharing there. I'll share and then. Okay. So our next speaker is. So thanks for that discussion. It's actually been. I have a dozen questions myself. Feel free to post your questions to Attorney Romel, Professor Romel. There's a Q&A button here, or you can post if you're watching us from Facebook. Post your question. There's already a question on the comment section. We'll pick that up and ask it here. So some comments already on Romel's presentation coming from some guy we know, Marnie Thompson. So thanks for logging in and joining us, Marnie. Our next speaker to talk about another equally important right, which is the right to privacy. And I'm really excited about this talk because I think it's very, very important. Is Attorney Jam Jacob. He is the legal and policy advisor for the Foundation for Media Alternatives. He graduated from UP with a degree in sociology and later with a degree of law, Juris Doctor. He earned his LLM in human rights law at the University of Auckland and studied data privacy at the University of Amsterdam. He was, for a time, the Privacy Policy Officer, perhaps the first director of the Privacy Policy Office of the National Privacy Commission. I believe Jam was one of the first employees of the National Privacy Commission, and maybe we can make him admit later, but I'm sure he was instrumental in shaping some of the early policies and policy direction of the National Privacy Commission, having provided a lot of the legal support for that. He's currently the director of the University Data Protection Office of the Ateneo de Manila University. He's also a writer for GMA News and Online and News Bites. And he's a certified information privacy manager. He's a regular resource person at various local and international privacy fora, such as those organized by the UN, Privacy International, APC, Facebook, and Google. So we'd like to welcome Attorney Jam Jacob. Jam?
Yeah, thank you, Sir JJ, and to everyone who are tuning in right now. Okay, let me just share first my presentation so I can proceed. Okay. I'll also dive right into my presentation to make sure that I'm able to finish within the time allotment, and so that we can also have more time for all the discussions later on for all your questions. Okay, so my topic for today is supposed to be about the right to privacy in the online space or in the digital world. But before I do that, I think it's important for us to have a shared understanding first of two key terms, which is privacy and the right to privacy rather, and then data privacy, because I'm going to mention these two terms a lot of times during my talk, and then at the same time, a lot of people tend to confuse these two terms with one another. When we're talking about the right to privacy or privacy in general, I think we can safely borrow that definition provided by Justice Brandeis and Samuel Warren in their seminal article on the right to privacy, which is about the right, that this particular right being the right to be let alone, or having this space to ourselves away from the prying eyes of anyone or everyone else, literally and figuratively. So that's the right to privacy. Next, we have data privacy, which is just one of the many manifestations of, well, not too many, but of several manifestations of the right to privacy. So that's data privacy for you. In the EU and in some other jurisdictions, they actually have a different term for it. It's called, or they refer to it as data protection. So as far as data privacy is concerned, it's a person's right to have some semblance of control over his or her personal data. Or to flip it, or stated otherwise, we could also say that it's the right against the unauthorized processing of our personal data. So it's not just about keeping our data away from others. It's making sure our data is protected even while it's in the hands of other people or in the hands of organizations. So these are the two terms that I hope are clear to us as we move along. So they are related terms, but they're not exactly the same. Not all privacy issues are data privacy issues, and vice versa. And so therefore, not all solutions to some privacy issues may be appropriate solutions to some data protection or data privacy issues. Okay, so for my talk this afternoon, I'm going to touch on both of these particular set the context because I'm going to focus on the problems or on the threats that we face right now as far as privacy is concerned, as far as our rights to data privacy is concerned in the digital world. So let me first, or let's set the table, so to speak, or set the context. So whenever we say we're now living in a digital world, what do we mean exactly? I think Romel also touched on this a bit earlier, so I'm just going to add a few numbers, figures, to really illustrate what we mean when we say we are now living in a digital world. So as far back as 2017, so that was around 3 years ago, according to the ITU, International Telecommunication Union, around 46% of households in the world already have a computer. And then 59% of us, people in the world, are now connected to the internet, are now online. And of those of us who do, we actually spend now more than 100 days online every year. So imagine how much time we spend online every year. Maybe it's not actively doing something online, but the mere fact that we are connected to the internet, I think that's what they're trying to say. And then as far as social media is concerned, 50% of the global population are already in social media. Of course, most of us are in Facebook, the biggest of them all. The average time we spend online or on Facebook or on social media rather would be around 2.5 hours per day. Now let's localize somewhat these figures and take a look at what's going on here in the Philippines. So actually Romel and I have the same reference in some of these figures. So according to one particular source, 67% of Filipinos are now considered active internet users. And we spend actually nearly 10 hours a day. And I'm guessing that this figure will have increased or must have increased ever since March of this year when this pandemic really took its toll on everyone. And then around 73 million Filipinos are active in social media, spending on average 4 hours a day, which is higher than the global average, which is 2.5 hours a day. Oh, by the way, that 9 hours and 45 minutes spent online, that's actually the highest in the world. So apparently, we're the people that spend the most time on the internet. Now, whether or not that's caused by some service or connection issues, I think the speakers next week will have more to say about that. Okay, so with these figures, all these are poised to go up even further. And that is because every day, it seems like we're always finding new ways to connect something that we are doing now, we are using now, to the internet. And this is that phenomenon we refer to as the Internet of Things, which Romel also mentioned earlier. Now, the second half of the context that I want to establish is how much data, specifically personal data, is playing a huge part in this digital transformation, because it is playing a big role. Today we are producing so much data that just take a look at what is supposedly happening. These are figures given for last year, actually 2019. So these are just some of the figures that they say we get to do within 60 seconds of every of every hour or every minute of every day, any day of the year. So around 18.1 million text messages sent in just 1 minute, 188 million emails sent, 390,000 applications downloaded, and it's just from Google Play and Apple Store. So this is just a snapshot of what of how much data we're actually generating, we are producing every single day. Now, these numbers are these numbers also are poised to or are supposed to be higher rather if we're going to consider the fact that these are just information we've been able to gather about mostly tech companies. So there are all these other private businesses out there. Then of course there's government. Government also is a big collector of information and processor of information. So if we can consider all those information that these other entities are collecting, generating, and processing, then it's supposed to be bigger. We're supposed to be looking at higher numbers. Now, if you're still not convinced that we're really producing that much information, just consider this one specific, I should say, estimate. According to one estimate, if we take all the information that we as a race, the human race, have been able to produce since the very beginning up until the year 2000. So this 2 millennium worth of millennia worth of data. If you can imagine how much information that is, it is said that today we are producing just as much information in less than an hour. So that's how much information we are churning out every second, every minute, every hour of every day. Now, so this explains basically why there is now a growing list of tech companies in the world's top businesses. Because these are the same companies, these are the same organizations that have been successful actually in coming up with essentially a new business model that thrives from from the processing of our personal data, of data in general. Uh, and as far as these companies are concerned, starting in the year 2014, most of them actually are now found here in Asia. So since 2014, there are now more tech companies here in Asia than in the entire United States. So there has also been a shift in terms of the epicenter of where all these new technologies are getting or coming out from, or are being developed rather. Okay, so now that we're done with that setup, with the context of where we're going to look at in terms of what problems are we now facing in terms of our right to privacy, in terms of our rights as provided under our data privacy or data protection laws. Let's now proceed to these problems or these issues. Now, there are so many issues, so many problems out there, and I cannot, we won't have enough time, even maybe a semester's worth would be sufficient to discuss all these issues. So what I did was just to come up or to limit my discussion to three main problem areas or themes, wherein I tried to cram as much of these different issues under these three themes for purposes of our discussion today. So what is the first major problem, first major issue we have in the digital sphere when we're talking about privacy, when we're talking about data privacy? So the first one is how this digital transformation has facilitated the proliferation of so-called data-intensive systems, which by their very nature actually challenge the very data protection laws and the very our very notion of our right to privacy. So what are data-intensive systems? These are systems basically or technologies that operate around the collection and processing of our personal data, especially on large scales. So hindi ito yung paunti-unti lang, but on large-scale processing of personal data, of our personal information. So today, because of the digital society, of the digital world that we have, there are so many of these systems now all around us. And I guess we can classify them according to who is behind them. So there are, of course, DIS or data intensive systems being maintained or managed by the private sector. Perhaps the most common or familiar to us are, of course, all these social media platforms and how they have been able to monetize actually our personal data. Another good example for these systems that are being managed by the private sector are all these different products that have been developed by the fintech sector or fintech industry. And perhaps here in the Philippines, the most famous, or should I say infamous, among these products would be all these money lending applications. We all know by now that since last year, we've received so many complaints or problems with respect to these lending apps. But in any case, these are data intensive systems, and what they do essentially is collect all this information about us, not just the traditional kinds of information that lenders collect. So they collect information about how we input the names of our contacts in our phone book. They collect information about how often we use our phones, etc., etc. And they use this actually to profile us. They use this to assign to us our credit score, and that's how they determine if they would like actually to let us borrow some money, and so on and so forth. And of course, as all these news articles have shown, these companies also tend to use all this information for other purposes. Some of them less noble, and some would even, I would say, qualify as criminal. So these are two good examples as far as data-intensive systems are concerned in the private sector. Now, if we shift to the government, this is where we will find the more familiar and more traditional information systems that we've come to know. So this is where we find the digital identity system. So right now, our government is rolling out the PhilSys. Now, ordinarily, or in the past rather, national identity systems are not necessarily part of the digital world. But today, they are. That's why in countries that have old identity systems in place, they're coming up with digital identity systems now to upgrade their legacy or their old systems. So we have the Philippines PhilSys, we have India's controversial Aadhaar identity system, and so on and so forth. And then we also have health information exchanges, rather, which is also about sharing of our health information between healthcare providers. We have SIM card registration systems, which is maintained actually in a lot of countries, a lot of other countries. Over here, we don't have one, but it's being proposed essentially every year by our legislators. And then you have unique ones like China's new social credit system. So all these government established and maintained systems are considered data-intensive systems. And then finally, we have the last batch, which are more or less the result of collaborations between the private sector and the government. So this is where big data center projects may be found. This is where smart city projects may be found. So over here in the Philippines, for instance, we've had tie-ups between cities like Makati, Davao, and I think Cebu with IBM. We currently have, I think, a smart city collaboration also between the city of Taguig and Huawei. And even that Safer Philippines or Safe Philippines project, I think, between DILG and, if I'm not mistaken, Huawei also. So these are also part of smart city initiatives, which are obviously collaborations between the private sector and the government. So all these are what we would refer to as, or what some would refer to as, data-intensive systems. Now, when we're talking about data-intensive systems, uh, people, those behind them, proponents rather, uh, would always like to highlight their supposed benefits. And these are just some of those benefits that they like to tell us. So they say, because of these systems, we have more evidence-based decision making, which essentially says the more information we have, the better decisions we are able to make. So supposedly, this also facilitate better public access to services, not just government services, but even those offered by the private sector. These are supposedly also useful as tools for crime prevention and, to some extent, crime solving. And then as far as the private sector is concerned, of course, they enable private companies to maximize their profits because of this data intensive systems. Now, there is a grain of truth to all this, though I would say that the benefits tend to be exaggerated in most cases. And I think that's what the reason for that is because the proponents of these systems would like us all to focus on those benefits. But like all technologies out there, there's always a flip side. So these technologies, with all the with all the benefits rather that they promise to give us, they also have their baggages. They also have their issues. Now, as far as data-intensive systems are concerned, there are several issues out there. Not all of them concern privacy or data privacy. There are several about privacy and data privacy. And if you were to ask me to pinpoint or identify or single out one that would stand out, I think it's how these systems enable the misuse and or the abuse of our personal data. Now, when I say that, so these are just some of the examples that I think most of us are either familiar with or might have heard of in the past couple of years. So we've heard of data intensive systems facilitating new forms of harassment and discrimination, like how, for instance, like how China's smart city projects supposedly are being used to control their minority communities, like the Uyghur communities over there in China. We've also heard, or there have been also news reports about China's social credit system and how and what are the consequences if you happen to uh, become one of those people who violate certain norms or rules there in China, and how you are then profiled by the system and get to be penalized or punished in so many different ways, whether it's being unable to enroll in certain types of schools, being unable to purchase or enjoy certain types of public transportation, and so on and so forth. So that's as far as government is concerned. When we're talking about the private sector, there have also been all these scattered news reports, stories about the people behind these data-intensive systems making use of the information gathered through these systems and using them for all sorts of purposes. And a lot of them are not good ones. For instance, here you have that Uber executive tracking the movements of particular journalists who happen to have Uber installed on his phone, because I think, if I'm not mistaken, that journalist was not saying a lot of good things about Uber at that time. And then there's this other news report also about other Uber employees using their system to spy on their former lovers, on politicians, and on celebrities. Over here, the violation has not been that high tech, but we've seen also how certain users of their app or drivers in most cases, use the information generated or collected through the app for other purposes, and they have been called out for those types of behavior. And then finally, of course, another good example, if anyone has seen this particular Netflix documentary, The Great Hack, then or better yet, if any one of you is familiar or followed that news story about Cambridge Analytica, which Romel also mentioned earlier, then you should also know, or we should also know by now, how actually our personal data uh, shared on a platform like Facebook could actually be used, packaged, and eventually would be weaponized essentially and used to undermine democratic institutions like the electoral process. So these are all just a sampling of all the things that happen, or the negative things that happen as a result of data-intensive systems, which we can attribute to this digital transformation that we are going through. The second, which I inadvertently already showed earlier, is how digital transformation has also facilitated the steady but steep rise in cybercrimes, specifically those crimes that relate to privacy or which involve personal data. So we can just take a look at all these headlines, for instance, rising incidents in terms of on identity thefts, doxing, harassment, cyberbullying, and then of course, hacking. The most famous, of course, is the Comelec incident that, way back in 2016, which was essentially the very first case handled or investigated by the National Privacy Commission. Of course, just this year, we also saw this headline of the NPC itself experiencing its own hacking incident. Although supposedly, according to their reports, there were no personal data involved or affected in that particular occasion. But the bottom line here, and I think what I'm trying to say is that all these things have been made possible because of our shift to the digital sphere, to the digital world. And then finally, the third one is how this digital transformation has also ushered in the emergence of a real life surveillance society. So all that, or that particular dystopian world, Orwell in his 1984 novel, we are now seeing it firsthand today. And I think what Edward Snowden showed us way back in 2000, was it 2013, was just to give us a sneak peek on how bad it is already today when we're talking about the surveillance activities being done by the government. And as far as Snowden is concerned, in the spotlight in that particular in his revelations were just the Five Eye, the so-called Five Eye. So that's the US, Canada, UK, Australia, and New Zealand. But basically, all governments carry out their own surveillance activities. Some of them valid for the protection of national sovereignty and so on and so forth. Some of them less so. That being said, if anyone also, or if any one of you have also watched this other Netflix documentary, The Social Dilemma, if that particular show told us anything, it's that the private sector is just as guilty. So when Edward Snowden came out with all that information, he more or less also showed some aspects there wherein some private sector entities, some tech companies were said to be cooperating actually with the government, with government spying institutions. But as far as The Social Dilemma is concerned, this particular documentary is concerned, it focused on the surveillance activities, mechanisms also, or rather, that are being perpetrated by the tech companies, by the private sector entities on their own, for their own benefit. So private companies tend to build their surveillance mechanisms into their platforms, into their systems, while governments, on the other hand, like to keep it secret, or they actually try to justify or legitimize it through laws and justify it through boilerplate justifications like protection of national security, necessary for public order and public safety, and so on and so forth. And this is why we have all these controversial laws like the Anti-Terrorism Act. We have the implementing rules of the Cybercrime Prevention Act. Romel mentioned earlier about that particular Supreme Court case striking down the real-time collection of personal data, but that was somehow revived in the implementing rules for a time that was supposed to be unlawful or unconstitutional. But ever since our country signed into the Budapest Cybercrime Convention, I think that has more or less been that defect has more or less been somewhat cured by that particular treaty. Yeah. So moving forward, I've also identified some contributing factors in terms of how these problems we have now are being confronted. So these factors make it more difficult for us to address those three key problems that I identified. So what are these contributing factors? First is you have your lack of effective laws or regulation. So although the list of countries with data protection laws is growing, I think, every couple of months, there are still many out there who don't have one. And for those who have one, like ours, there are still quite a lot of policy gaps to fill. So that falls on the shoulders rather of regulators or the data protection authorities. And then there's also the fact that in some cases we have a law. It's just that the regulator or the implementing agency is weak as far as implementing it is concerned. Now, weakness can be manifested in so many ways. It may be weak because it may not have the necessary powers to carry out its mandate. It may be weak because it lacks manpower, it lacks resources, funding, or it could also be weak because it lacks the necessary competence or expertise to actually perform its job. And then finally, you have regulatory capture. So in this case, you may have a law in place, you may have what is arguably a competent regulator. It just so happens that it has been compromised. So what frequently happens is when your regulators cozy up to the very same entities they are supposed to watch over, then they effectively become useless. And here in our country, I think there are certain regulators that civil society and consumer groups readily identify as supposedly subject to this, or subject rather to regulatory capture. Okay, now finally, let's proceed to how then do we deal with all these problems. If you have those many problems aggravated or made worse by all these contributing factors, what do we now do? So I've listed down 4, and I know they sound like motherhood statements, but later if we have the time, I'll be more than happy to discuss them more in detail. But these are the 4 that I was able to identify. First, we have to make sure that all these technologies are always grounded in law. That means, especially for those created and mandated by government, we have to make sure that there are necessary safeguards in place as far as those laws are concerned, with a healthy amount of transparency also. So hindi pwedeng napaka-opaque nung how these systems are being managed or being operated. Of course, all these technologies also must be compliant with privacy and data protection laws, such as they should recognize data subject rights. They should prescribe mandatory data breach notification protocols. The second one is for us to have an effective oversight by a competent and independent regulators. And I would even go further and say the judiciary as well. They must also be competent in that regard. In the same way that we are educating our judiciary as far as cybersecurity, cybercrime are concerned, I think we should also be doing the same for data privacy. And I think that STC case is a good example of why we need to do that. So regulators need to be given the necessary powers. They need to be given the necessary resources to perform their job. But at the same time, they have to be effective in performing their job as well. They need to make sure rather that they are competent enough to perform their functions. And they should now not allow themselves to be compromised and used by those with vested interests. Third would be for there to be always an active and vocal civil society. So whether it's NGOs, the media, and even academic institutions, we need to be ready to assist the government, regulators, whenever they need our assistance. But at the same time, we have to be ready to keep them in check in cases there are abuses. We, as that age-old adage says, we need to continue speaking truth to power. Tell the government when it has overstepped its mandate. And as far as the government is concerned, it needs to be open-minded and welcome all these criticisms, not shun them, not set them aside, because that's the only way for all these problems to be properly addressed moving forward. And then finally, as individuals, we also need to be empowered as citizens, especially as data subjects. So we need to be aware of all these laws, applicable laws and relevant laws that govern privacy, data privacy, especially in the way they relate to technologies. And be ready also, especially those that actually give us rights. And then whenever necessary, we also have to be prepared to exercise those rights, even when it's not that convenient for all of us, such as filing cases. If we may think that it may require too much work, but if that's what's necessary to make sure that companies are actually complying with all these laws, these policies, then we need to be prepared to do that. Okay, so I'm going to end there. I just have one slide left. I started this discussion by setting a common understanding of what we mean by the terms privacy and data privacy or data protection. And I'd like also to end with a shared belief among all of us as citizens, as data subjects, in terms of how we should approach technology. And that common belief is this: we should, as a people, believe that technology actually exists to augment our weaknesses. It's not supposed to take advantage of our weaknesses. If you watch again that Social Dilemma, you would know more what I'm talking about. So as citizens, we need to make sure that these technologies actually guarantee our rights or even enhances them rather than undermines those rights. And then together, we should also believe that true progress, the kind that is promised by a digital future, a digital world, should never be at the expense of our fundamental rights, such as the right to privacy and the right to data privacy. That's it.
All right. Thank you. Thank you, Attorney Jam. So, okay, so thanks for that. We will, I just have a couple of sorry for me, for a second here. I made a list of the people who signed up and are watching us now. I made for them. So I'll just read out. So from, I think I try to do this from north to south, no? So I'm seeing some thank yous already from people who listen to your lectures, to your talks. Thank you also. I'm very grateful. So we have from Nueva Ecija, Cabanatuan, Nueva Ecija, Nueva Ecija University of Science and Technology. Welcome. PRMSU from Iba Zambales, San Fernando, Pampanga, Subic, Quezon City. We have somebody watching from the House of Representatives, and next door from the Commission on Audit, COA. Makati, PNU Manila, Manila, San Juan City, San Mateo Rizal, Parañaque, Dasmariñas City, Cavite, UP Los Baños, Santa Cruz Laguna, Bulacan, Camarines Norte, from Masbate, Dr. Emilio B. Espinosa Sr., Memorial State College for Culture and Technology. Thank you for joining us. Cebu, we have somebody from Iloilo City, and Zamboanga City, Malaybalay, Bukidnon. So I guess I'm I'm happy to report that we have how do you call this? We have people watching from all over the country. So I guess we'll go to the next part where we'll discuss how do you call this? The Q&A. We'll jump into the Q&A. So we're seeing a lot of questions here. And let me see. So siguro maybe there's an interesting question here. Maybe we'll start off with Jam. So there's a question: isn't the Constitution and Data Privacy Act supposed to protect our privacy and personal information?
Well, yes. We have there, and jurisprudence, Philippine jurisprudence would actually attest to that the right to privacy is actually protected under the Philippine Constitution. As far as data privacy is concerned, that's more within the purview or the scope of the Data Privacy Act. So that's why it's there. So there is a bit of uncertainty in terms of if you're asking if whether is data privacy itself featured in our Constitution, because as I mentioned earlier, while it is a manifestation or in some way an aspect of the right to privacy, it's not a parang one is to one kumbaga correlation. And I guess the best example to highlight this is that in the EU in the year 2000 actually, what they did was they carved out the right to data protection from their right to privacy. So in the EU Charter, if you will look at that particular document, separate na yung the right to privacy and the right to data protection. But here, since we're talking about the Philippines, yes, the right to privacy is protected under our Constitution. And as far as data privacy is concerned or personal information is concerned, it's protected under our Data Privacy Act.
Okay. I think there's and I'd like to address this to both of you. I think there's a link between the right to privacy and freedom of expression, where, and we've seen this, I guess, more recently, where information or something is ascribed to somebody in order to suppress that person's ability to express himself. So more recently, siguro, this phenomenon of red tagging, where an individual, say, sino ba? There was a celebrity was red tagged, no? I forget her name. Locsin, Angel Locsin, right? And so what happens is you have information about her, you release that information, but the intention really is to stop her from expressing her freedom of expression. So there's this strong link between them. I guess in that sense, Romel, you've seen that, no, in your own experience, and how have you seen that play itself out in the past?
Well, so now we before there was the how do you call that order of battle, no? Nung unang panahon ni Jimmy, order of battle, tapos drug list. Yung drug list naging a list of dissidents or list of alleged communists, ano? So there might be several violations spanning privacy and international humanitarian law, because in IHL you make a distinct. International humanitarian law is the law dealing with armed conflict. No? So if there's an allegation that a person is a member of the NPA, so he or she is a combatant. No? But the IHL actually makes a distinction that if you are a non-combatant, you're not supposed to be targeted. But we saw that if you are red tagged, after a few months, you're killed, no, in the Philippines. So all these people being killed in Bacolod, in other parts of the country, they were first posted in on Facebook or in physical locations. No, there were notices that they are members of alleged communist groups, and after that, they were gunned down by people we don't know. Secondly, I think you can actually question that, because it's, if that's not true, of course, no, you can file a writ of habeas data and a writ of for a writ of habeas data and writ of amparo to actually force the AFP to tell the court exactly what are these information that they claim to have gotten about me, about that person. So there are actually remedies that can be used in court for that.
And you've done that. You filed this writ of habeas data in favor of of individuals who've been investigated by court. And what's your experience with the courts? Have they been effective?
We have more success in amparo. In habeas data, I don't recall any case that has been successful so far. Maybe there is some misunderstanding on the part of the court what habeas data is. Even that landmark case Bagares, where the court expanded the availability of habeas data. The understanding is that it's just against the state, but in Vivares you can already file an habeas data even against a private person. But it was not even successful. The petition was denied, but the court just clarified the scope of habeas data. So it appears that the Supreme Court has, while the rule is there, but so far I have not seen any successful case of habeas data. It's mostly the amparo.
But it seems to me, but writ of amparo is a bit more narrow. It's a narrower remedy.
Yeah,
it's more of how would you say that? It's I guess it was really designed for those who were
for threats, for threats to your enjoyment of rights. The habeas data is the threat. If somebody's collecting information about you without your consent. So it's it's another remedy outside of the Data Privacy Act. Because Data Privacy Act deals only with personal information, sensitive personal information. But although there might be some interfaces between the aim of habeas data and the Data Privacy Act, for that matter, I think that they are not exclusive. It depends on what you want to achieve. But in this case, yeah.
So that's a good point, and I'm wondering whether Jam, you can foresee, for example, an individual filing a criminal case against, say, a government official, let's say a military official, claiming violation of Data Privacy Act, sort of unauthorized collection of personal information, and sort of tying that into a freedom of expression claim, but sort of putting a bigger threat from the standpoint of a criminal offense. What do you think?
Yeah, I would like to think that that's possible. In fact, you mentioned unauthorized processing of information, which could translate to unauthorized collection of information. And then you can also combine that with that other offense of malicious disclosure of personal information or sensitive personal information. Para there's the provision under the Data Privacy Act that if it's one or two, when it's two or more acts, then it elicits or it would actually require higher penalties on the perpetrator. But given the situation you described, I think it's worth a try, kumbaga, to test the teeth of our Data Privacy Act. Kasi for now, wala ako so far. I keep hearing about this case about a former BPO employee being convicted in the trial court, although I don't know what happened eventually to that. But I only saw that at a particular website of a particular law firm. I haven't seen actually a news article about that.
Okay, so it's interesting. Now, so you raised something important. So let me just go a bit on the data privacy side. So we know it's a criminal offense. We know there have been many cases filed at the NPC for the online lending platforms. Okay. It wasn't so much as the lending activity as it was the collection practices, where I think, and I think that really puts to highlight the difference between compliance with the law and understanding data privacy as a human right. Because I would think, I'm not sure, I suspect many of those companies who were accused of violating data privacy rights could probably point to a consent form in their process, which says that they gave them consent, right? The consent was procured. Is that the case? Were you aware of some details of
I
those
think
complaints?
since we at FMA actually are writing a paper on this, so we have some sort of inside information on some of these things. Uh, as far as the collection part is concerned, I think the argument there in terms of unauthorized collection has to do more actually with all those people in the contact list of the individual. Because if we're talking about all those people, if I'm in the contact list of this individual who actually filed a complaint, or who was actually the victim of harassment, etc., or the borrower, rather,
Right.
even if the company is able to say na, the borrower gave his or her consent when he or she downloaded our app, etc. But as far as I'm concerned, it's my information in his or her phone. Where is my consent there? So I did not give my consent. So I think that's the avenue to pursue if you're going to accuse the companies of unauthorized data processing or unauthorized collection. But as far as the majority of the complaints are concerned, I think it has to do more with how they use that information to to harass people, not just the borrowers, but even those people they know, those people on the contact list. So I think these are the two parts that can be that either the NPC or even the courts can focus on in terms of determining if these companies are in fact liable under the Data Privacy Act.
Okay, so interesting. So you mentioned, I think, a very, very good sort of legal and compliance issue. That's a limit. That is a limitation of consent. I can give consent. You can do anything with my data, but that doesn't give you. If I give consent for you to raid my address book, you're actually collecting other people's personal information as well, and it's questionable whether or not I can give consent to collect their information because you're using now that information to send messages to these individuals. But I think the other, so a couple of issues for me came up also in relation to the online lending, and I think one of them was this concern that is this a proper use of data privacy law on the one hand, because from the standpoint of the lender, what they're seeing is these are people who borrowed money and are not paying it back, and they're using the Data Privacy Act as a way to
escape accountability.
escape if not delay, right?
Okay.
Sort of push back on the lender. I mean, they eventually they will have to pay. They know that, no? But at least tone down on the collection practices so that the pressure on me to repay isn't as great. So did you see some of that as well? That these were just
From a privacy advocate, actually, I would tend to focus more on the harassment part. As far as the data collection is concerned, I think that is the more complicated issue to that we have to unpack. I think it's not just the NPC recently came out with a circular that says explicitly that so from now on these companies should no longer collect information in the contact list of individuals. But in my case, based on our studies in the paper that we will be releasing pretty soon, the precise business model of these lending companies is that they utilize all these non-traditional sources of data in order for them to make a determination whether or not they will be willing to take the risk and lend you money, because compared to more traditional lenders, yun nga, parang wala rin yung safeguards, usual safeguards that are supposed also to protect the businesses, the lenders. So in this case, it's different. In a matter of seconds, you can actually apply and then get approved yung application mo for a loan. So ang trade-off, of course, is these companies collect all this information na I think as individuals, as in the public, and even I suppose from the regulator's perspective, we don't really fully understand, because all these to come up with their decisions, they have these algorithms that are usually protected under proprietary laws, IP laws. So just like Facebook na ayaw i-disclose, let's say, how they actually try to influence us in what we do, in what they show us. Same thing with the lending company. So I think that the solution is not as straightforward as you are prohibited from collecting this. Because if you do that, then ang ibabatong question sa iyo ulit. So how then, as a business, do we now decide if we will give this person a loan? I cannot see him. We're not here face to face. And all this information that he or she will be submitting, mga IDs, mga picture lang yan. So who knows if peke yan or if gawa lang siya sa rector. So they come up with this alternative mechanisms. No, regulating that alternative mechanism is, I think, the bigger challenge.
Okay, so I think the problem that you're raising is something I'm going to segue a bit to Romel now. But I think this question is relevant to the both of you. Parang there's a collective action problem, right? So there are, what's happening in the data privacy sphere is that individuals, maybe there's violation at the individual level of, pero in a broad way, because many people are affected, many people are borrowing, but they can sue, right? Very easy for them to sue on their individual issue, but the amount might be small enough, too small that they cannot. So collectively, there's a big violation given the number of people, but individually it's too small to bring forward. And the reason why I'm tilting this towards Romel, because I think the issue now, when you talk about that from the standpoint of freedom of expression, is, when you talk about things like you mentioning earlier about suppression, right, of opinions through social media. These are small harms, but when you look at it, it's a big harm collectively. And I'm wondering whether, and since you've actually brought cases and have litigated human rights cases, do you think that problem exists, that this collective action problem exists in terms of defending these rights in the courts? And if it exists, would you suggest any solutions?
Oh, yeah, definitely. That's a problem, because number one, of course, people are speak out. And they don't really know what their rights are. So if you're talking about, for instance, lending, all this, microfinance, and I personally, I believe the model. So if you really go back to the principles of data privacy, proportionality, transparency, and legality, for collecting data. So right away you will see that these practices really violate the closing to the borrower. What's the purpose for getting all this data? And then proportionally, you really need all of those data for having all these to have clients or borrowers. And I think in the National Privacy Commission, I don't think there has been a case where you have this collective action filed against one party. It's always individual. So I don't also know if I've come across the procedures of the NPC. If there is such a provision for collective action, like let's action suit in civil law. There's I don't think the rules of the NPC actually allow that or embrace that particular mode of or remedy.
Right. Actually, so in that sense, I know you've brought cases involving Tokhang, for example. So this is a problem that involves thousands of individuals, thousands of people, right? And yet, you, as a matter of bringing a case before the courts, you have to look for a particular person, a particular plaintiff, as opposed to filing as a class. Do you find that the current state of the law is so restrictive to bringing class action suits that it harms the ability to defend or, I guess, enforce human rights?
Yeah, that's actually an unexplored question, even in the scholarship on class action. Of course, that's what we've had experience. Although I think prevailed in one aspect for free expression. The courts there's a cause of action, Article 32, for violation of constitutional rights under the Civil Code. So, but it was remanded to the RTCs, and where it's still pending. So it's a long process. That's one thing that you also have to consider. So that case was actually filed like 10 years ago. It took the Supreme Court 3 years to rule on whether there's a cause of action after it was brought on certiorari to the Supreme Court. It was remanded to court, where it lagged. I mean, it counted
Languished.
years before before there was a new judge that was appointed, and who opened the proceedings again. So that's the thing. Also, there's this problem in courts where the procedures really take a long time. So that's one barrier to effective remedy. And effective remedy is a right guaranteed under both international law and and constitutional law. No, it's a right that every citizen has, that he has a right to effective remedy. And if there's a delay, then your right to effective remedy is already violated.
That's interesting, and I think that's going to be a problem as well in the data privacy field, right? It's a small violation that add up to a large harm that are and find no solution. Is that what you're going to? You mentioned the paper that you're about to release on FMA jam. Is that are you finding that that's going to be an issue?
Which one?
The fact that there's the fact that there's there's all these small harms, right, at an individual level, but no way to collectively pursue.
Yes. Well, I think that's the one key difference that we have, our data privacy regime here compared, let's say, to the EU. Kasi doon, that is actually made possible. People are allowed to be represented actually by nonprofits even to file cases before their data protection authorities to pursue cases against all these, especially big companies. So in here, I think we've seen that on those statistics, those numbers released by the NPC na yun nga, thousands even yung cases that have already been filed. And based on, as far as I'm concerned, or based on my recollection rather, on the rules, the procedural rules of the NPC, I don't recall any provision there facilitating the filing of class suits, for instance, or something like that. So I think, yes, it is something, I suppose, that the commission should entertain and then maybe come up with certain rules to make it easier for all these individuals having essentially the same cause of action against companies operating in the same way. Para
right.
to make it also easier for them to resolve all these types of cases. But for now, the way the procedures are written, you have to be essentially a data subject na naapektuhan, or
Correct.
Your privacy was violated, and then you have to personally file it with the NPC.
Right, and I think that one of the biggest problems now is how do you measure the extent of harm, right? So under Philippine law, baka sabihin ng court,
Correct.
well, you didn't, there was no pecuniary harm, so we'll just give you nominal damages, some fees 50,000 or 20,000, and you go on your way. So what happens is unless 1,000 people file, the harm on the impact on the company might not be too much. So
Correct.
There's a very good question here, and I think I'll throw this to the both of you, that when you talk about the platforms that where social media happens, where freedom of expression is impacted, or data privacy, there's an impact on data privacy. These are offshore platforms, and so the question is, how can state regulators effectively enforce data privacy protection, freedom of expression rights when these are transnational offshore companies? Do you have any thoughts on that?
We'll answer first.
Yeah.
Okay. Well, that's actually one of the things that have been discussed by different activist groups now. Like Facebook has a Philippine office, so it should not be a problem. They have a Philippine office now. Google, I think, on YouTube, they have an office, and that maybe is indication of the amount of business being generated by those companies. So that should not be a problem. Plus, also in our new procedures, the DOJ now has a procedure for international warrants. I don't know if people know about that, but there's now that availability for Philippine lawyers which is coupled with the treaties we have with different states. So it's actually possible now to issue summonses. The DOJ does that now on a regular basis for requests to foreign-based entities, persons or companies, for data, that have a relationship to a case in the Philippines. So we do have these remedies now, and that's really one of the important things about imposing accountability for such very big and very powerful companies. No, one aspect is the jurisdictional question, which is having a Philippine office. The second one is the monopoly. So in Europe, they've been very effective about that, looking at the side of monopoly. In the Philippines, we now have a Philippine Competition Commission. So it remains to be seen whether our PCC would have also developed such a competence to hear questions of monopoly related to all these social media platforms.
Okay, Jam?
Yeah. There is that's a major problem as far as the Data Privacy Act is concerned, because unlike in the EU, well, Romel was saying earlier about how effective the regulators in Europe have been as far as implementing their laws are concerned. But if you will read the Data Privacy Act, if the culprit is an organization or a juridical person, the penalty actually is imposed on the person or persons who either committed the offense or through negligence allowed the offense to be committed or performed or to transpire. So if we will take a look at that formulation in terms of who is going to be held accountable, I think it will be hard to prove that it's the people working based here in the Philippines who are actually making the decisions as far as how Facebook makes its decisions, or who was really responsible for the unauthorized processing of personal data. If our laws in the EU, on the other hand, they impose fines on the other organizations. Here, and I think that is one of the more problematic areas also as far as imposing fines in the law as far as criminal liability is concerned. So it's with a person. So that one I think will have a difficult time trying to enforce. But as far as the NPC, for instance, imposing fines, I think that is the hanging question as far as we are concerned. Because right now the NPC has no schedule of fines, and I understand they've also worked with UP College of Law or Law Center rather, as far as whether or that is possible to come up with those schedule of fines. But yeah, so that's the problem there. I guess another option is through all this cross-border cooperation with other regulatory entities. For instance, I guess that means NPC working with the FTC in the US, or at least the regional office naman ng Google and Facebook, which is in Singapore, then the PDPC of Singapore. So that's another avenue I think we can pursue as far as the question is concerned of how can we hold all these entities accountable.
So just so just for information of everyone, my understanding is that the Philippine office of Facebook and Google are marketing and I think support arms. So they handle the ad business, and then they provide support to customers in the Philippines. So these are not locally incorporated companies. I think they're branch offices. Now, but Congress now is considering a law, and I think this is what might be a trend, a global trend, where domestic legislatures are considering different laws to require these offshore companies to have some local presence, so that there's some leverage on local presence, and also for taxation purposes. Would you be in favor of the government moving in that direction?
In my case, I think if we did that, or if we do that, we're more or less following the footsteps of the EU as far as data privacy or data protection is concerned.
That's right.
I think there is a provision there in some for some entities, they're actually required to have an agent. I'm not sure if that is the correct term, a resident agent that has to be there based in the EU for accountability purposes. So yes, to that degree, I think that is worth exploring.
Yes. Would you think that would be a good idea, Romel? So what happens is, say you require Facebook, open a Philippine company, and then that Philippine company will be the point of contact for receiving these notices and complying with writs, and you think that's
I think that's one way of actually imposing liability, ensuring liability because of the transnational nature of their operations. So you have to tie them down to territory and jurisdiction. That's one effective way of
that's right.
doing that.
Right. But of course, I think the flip side also is that on the freedom of expression aspect, it also makes them vulnerable to political forces, right? Because if there's local, so the sort of the freedom that people have in using the platform might be eroded if they knew that somebody from the PNP can come in and start cracking down on message boards. So there's the offshore aspect of it. I think promotes interaction, shields from liability, but so it parang, I don't know if it balances out, but it's certainly something worth considering. Okay, so I think we're running out of time. So can I just ask either of you for some parting thoughts, and then we can close the session. I'd like to take this opportunity again to thank you for your great presentations, very enlightening and very thoughtful. So who would like to go first? Maybe Jam.
Naman, ako na una kanina.
Okay. Actually, sabi ko na yung parting words kanina. So I think just to add to that, our work really, I think Al and Lisa touched on this last week during their talk. So our work basically is about making sure that our human rights, Filipinos' human rights in particular, are adequately protected and promoted online as well as it is being promoted offline. So I think right now we are grateful that more and more people are recognizing that this is a very important advocacy, and there are more avenues such as this one where we get to articulate our advocacy and tell people actually that this is important and this is something we should do. Because I remember for a time there, I think the only people talking about data privacy was FMA and you, kayo, Attorney JJ. Yun lang yung may mga, and we had to essentially tell people na may free lunch just so that they would actually stay and listen to what we're saying. So right now it's a different world, and we hope, or I hope personally, that we continue as a society to push for this advocacy. The traditional advocacies of human rights are still there, but now we have to recognize the new world that we are living in, not just the new normal, and we need to continue the fight in this particular venue as well.
So I na-mention mo na rin that you will be doing that launch. So I hope we can call you back, you and Lisa and Al. I hope you can guest, and we can talk about your paper when it comes out.
Sure. Okay, sure.
All right. Thank you, Romel.
All right. Well, for me, when I was a journalist, I always remember this very brilliant quote from Ben Bagdikian, and it's something that's very relevant to us now. This was the time when the Washington Post was deciding whether to publish the Pentagon Papers. And against lawyers, Ben Bradley, or Ben Bagdikian, said that the best way to assert your freedom of expression is actually to practice. And today that requires courage, but we have to practice our right to free expression, to continue to protect it. Thank you.
Wow, that's so I think I'll end on that note as well. To say that both of our guests actually represent that. They are people who believe that these are values that are important in a modern society, and they are putting action to their words and their ideas. And so we're very happy and very honored actually to have them here to share their thoughts and their time with us today. So thank you. I'll put the session to a close. Next week we'll be discussing the Open Access Act, and that talks about rights naman to open access. We will have the proponents of the open access law, as well as the perspective of industry as well. There was a mention earlier by Attorney Jam of Filipinos spending 9.5 hours a day on social media. And that's really quite interesting because when you think about it. Online, okay.
4 hours on social media.
Actually, I 4 hours on social media. So that's scary from the standpoint of employers, So you're saying on average, my guys are spending half their day on social media. Or maybe the average is skewed towards government. Maybe it's people in the government sector spending all of that time on Facebook. Nevertheless, this is all very important to us, and maybe one of the reasons why we're spending so much time is because the bandwidth is too slow, and that's the topic that we'll be discussing next week. So I'd like to put this to a close. And thank you very much for all our attendees. Please sign up for a certificate of attendance so that we can make the contribution for our COVID frontliners. We're actually considering also making a donation to those affected by the recent typhoon. So thank you. On that note, I'd like to put a close to this session. Thank you and have a nice day.